Our judicial system today works like a bad case of the game telephone. You probably remember that game from grammar school. The teacher would whisper something into one child's ear, who would then whisper it into the next child's ear, and on until the message got all the way around the room. Then the teacher would compare what they had whispered into the first child's ear with what the last child heard, and it would be completely different. This child's game shows the dangers of what I call a compounding replication error. The idea that small errors that occur when something like a message is replicated, compounded with each new replica until the original message is lost. This is how our judicial system works today, often with disastrous effects. In the case of Groff versus DeJoy, Postmaster General, most people see a win for religious liberty. I, however, see another generation of a compounding replication error in judicial opinion that, while granting the correct outcome today, lays the groundwork for the destruction of our rights and the rule of law tomorrow. So let's take a closer look at this case next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach your and generation be free. I'm glad you could join me today. This Groff versus DeJoy case, a lot of people have praised and lauded, but again, there are problems that I want to take a look at. Now, hopefully you'll go back to the website, constitutionstudy.com. You'll find the written article where you can find all the links to all the quotes that I use in this episode. Now, I'll talk some more about the website at the end of the episode, but for now, let's take a look at this U.S. Postal Service freedom of religion case. On its face, the case of Groff versus DeJoy, Postmaster General, seems quite simple. Can the United States Postal Service punish an employee for refusing to work on Sundays for religious reasons? Petitioner Gerald Groff is an evangelical Christian who believes for religious reasons that Sundays should be devoted to worship and rest. In 2012, Groff took a mail delivery job with the United States Postal Service. Groff's position generally did not involve Sunday work, but that changed after the U.S. Postal Service agreed to begin facilitating Sunday deliveries for Amazon. Groff received progressive discipline for failing to work on Sundays, and he eventually resigned. This seems simple enough. Mr. Groff took a mail delivery job with the U.S. Postal Service, USPS, which did not generally involve working on Sundays. When the USPS signed an agreement with Amazon, which included Sunday delivery, Mr. Groff moved to another station, a more rural one that did not offer Sunday deliveries. When that station began to offer Sunday deliveries, Mr. Groff refused to work those days, forcing the U.S. Postal Service to redistribute his work to other employees. This led to progressively increased discipline, which caused Mr. Groff to resign and file suit. Groff sued under Title VII of the Civil Rights Act of 1964, asserting that the U.S. Postal Service could have accommodated his Sunday Sabbath practice without undue hardship on the conduct of the U.S. Postal Service's business. The district court granted summary judgment to USPS. The Third Circuit affirmed based on this court's decision in Transworld Airlines, Inc. versus Hardison, which it construed to mean that requiring an employer to bear more than a de minimis cost to provide a religious accommodation is an undue hardship. The Third Circuit found the de minimis cost standard met here, concluding that exempting Groff from Sunday work had imposed on his coworkers, disrupted the workplace and workflow, and diminished employee morale. Both the district and circuit courts sided with the U.S. Postal Service, concluding that they only had to show a de minimis, Latin for minimum importance. They only had to show a de minimis cost to be able to deny a religious exemption. These courts came to this decision based on a previous decision called Transworld Airline Inc. versus Hardison. This is where we pick up our game of judicial telephone. Let's start where all legal cases should start, with the law. The Civil Rights Act of 1964 prohibited discrimination in public places, provided for the integration of schools and other public facilities, and made employment discrimination illegal. Title VII, dealing with employment discrimination, was added to the U.S. Code under Title 42, Sections 2000E through 2000E17. Within that law, we find It shall be unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. Later, the Equal Employment Opportunity Commission added regulations requiring that employers make a reasonable accommodation for religious practice. After an employee or prospective employee notifies the employer or labor organization of his or her need for a religious exemption, the employer or labor organization has an obligation to reasonably accommodate the individual's religious practice. A refusal to accommodate is justified only when an employer or labor organization can demonstrate that an undue hardship would in fact result from each available alternative method of accommodation. First, we need to note that the regulation is 29 CFR section 1605.2C1, not 1605.1 as the court claims in the opinion syllabus. This religious accommodation requirement was eventually codified in the U.S. Code under section 2000EJ. The term religion includes all aspects of religious observance and practice, as well as belief, unless an employer demonstrates that he is unable to reasonably accommodate to an employee's or prospective employee's religious observation or practice without undue hardship on the conduct of the employer's business. The law quite clearly states that employers cannot discriminate against an individual because of their religious observance and practice unless they can show doing so would be an undue hardship on their business. What is an undue hardship? Merriam-Webster's online dictionary defines undue as exceeding or violating propriety or fitness. In other words, excessive. And hardship as something that causes or entails suffering or privation. In other words, employers must make accommodation for religious practices unless it would cause excessive suffering or privation. However, in Mr. Groff's case, the Third Circuit did not base their decision on the law, but on their interpretation of a previous case, Transworld Airlines Inc. versus Harrison. The Supreme Court noted the error in using this precedent in their decision. Instead, the court's opinion stated that the principal issue on which TWA and the union came to this court was whether Title VII requires an employer and a union who have agreed on a seniority system to deprive senior employees of their seniority status in order to accommodate a junior employee's religious practice. The court held that Title VII imposed no such requirement. But the court's opinion in Hardison contained this oft-quoted sentence: to require TWA to bear more than a de minimis cost in order to give Hardison Saturdays off is an undue hardship. Although many lower courts later viewed this line as the authoritative interpretation of the statutory term, undue hardship, the context renders this reading doubtful. In response to Justice Marshall's dissent, the court described the governing standard quite differently, stating 3 times that an accommodation is not required unless it entails substantial cost or expenditures. Do you see how judicial telephone is so dangerous to our rights and the rule of law? How many lower court decisions were made on the faulty reasoning found in Hardison? How would Mr. Groff's case have been decided if this court had not gone to the text of the law? Well, back to the case opinion. To determine what an employer must prove to defend a denial of religious accommodation under Title VII, the court begins with Title VII's text. The statutory term hardship refers to, at minimum, something hard to bear, and suggests something more severe than a mere burden. If Title VII said only that an employer need not be made to suffer a hardship, an employer could escape liability simply by showing that an accommodation would pose some sort of additional cost. Adding the modifier undue means that the requisite burden or adversity must rise to an excessive or unjustifiable level. Understood in this way, undue hardship means something very different from a burden that is merely more than a de minimis, i.e. very small or trifling. The ordinary meaning of undue hardship thus points toward a standard closer to Hardison's reference to substantial additional cost or substantial expenditures. By now you may be thinking, great, Paul, the circuit court got it wrong, but at least the Supreme Court came to the right conclusion because they went back to the law. If that's what you were thinking, you're wrong. You see, the Hardison decision was based on a previous decision, Dewey versus Reynolds Metal Company, where we find this is an action arising under Title VII of the Civil Rights Act of 1964, 42 U.S.C. Section 2000E. which provides, among other things, for relief against religious discrimination in employment. Okay, Paul, so what's wrong with Dewey? Well, Dewey, which is the first case I found regarding Title VII of the Civil Rights Act of 1964, does not appear to have considered whether or not Title VII was even constitutional. Because an application of Title VII of the Civil Rights Act of 1964, 42 U.S.C. Section 2000E, will permit the court to decide the case, it is not necessary to reach the question of whether plaintiff's constitutional rights have been violated. See, the Dewey court recognized that the Constitution, either directly or indirectly, had to be considered, but not because the Constitution said so, but because another court had. An agreement which violates a provision of the federal Constitution or of a constitutional federal statute, or which cannot be performed without violating such a provision, is illegal and void. This, by the way, is Irwin versus Blue Jacket. Because of these views, the Dewey Court never appeared to question whether or not Title VII, the Civil Rights Act of 1964, violated the Constitution of the United States in the first place, which would have made the law void. This despite the fact that the court pointed out the unconstitutional nature of the law in their opinion. In relation to Sherbet, one might question its relevance, since in that case there was state action, while in the instant case there is only private action. That distinction would be important if this opinion were dealing with whether a defendant's overtime rule is unconstitutional. But the issue before the court is whether the defendant has violated a federal statute, a statute which restricts the activities of private employers and does not require state action. The importance of Sherbet to this analysis is not its holding on constitutionality, but its definition of discrimination, a definition which is equally valid whether employed to measure private or state action. Now, Title VII of the Civil Rights Act restricted the activities of private employers, which is not a power delegated to the United States by its Constitution. The term employer means a person engaged in an industry affecting commerce who has 15 or more employees for each working day in each of 20 or more calendar weeks in the current or preceding calendar year, and any agent of such person. But Congress is not granted the power to regulate commerce. Under Article 1, Section 8, Clause 3 of the Constitution, Congress has the power only to regulate commerce with foreign nations and among the several states and with the Indian tribes. Furthermore, Title VII does not regulate commerce, it regulates employment. Now, while it's assumed that Congress can regulate employment within the federal government, they have not been delegated any power to regulate employment outside of that sphere. This means Title VII violates the 10th Amendment. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Since Title VII is a U.S. law not made pursuant to the Constitution, it is not the supreme law of the land, at least according to the Supremacy Clause. This Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. And since the judges in every state are bound to the supreme law, including those of the Supreme Court who take an oath to support the Constitution, they should have found Title VII unconstitutional and therefore void. There is one good thing found in this mess, and that's the actual decision. You see, the U.S. Postal Service is part of the federal government. Its very existence came from Congress and therefore is subject to the First Amendment, which reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The United States Postal Service, an entity created by Congress, is barred from prohibiting the free exercise of religion, including observing the Sabbath. Held. Title VII requires an employer that denies a religious accommodation to show that the burden of granting an accommodation will result in a substantial increased cost in relation to the conduct of its particular business. So while the Supreme Court got it wrong, the outcome for Mr. Groff is correct. The judgment of the Court of Appeals is vacated, and the case is remanded for further proceedings consistent with this opinion. When I was young, my mother used to say, 2 wrongs don't make a right. Well, that's true for this case. With everyone focused on the court deciding in Mr. Groff's favor, lost are the numerous wrongs that brought them to it. You may be asking, Paul, how can you be upset with a win for religious liberty? The answer is simple. Because it depends solely on the largesse of 9 black-robed oligarchs, and what the oligarchs give, the oligarchs can take away. This decision is founded on nothing but a towering house of cards waiting for the slightest breeze to blow it down. What happens when the next judge or justice arbitrarily decides that an employee's Sunday off is an undue hardship? Are you willing to bet your financial future, not to mention your rights, on how burdensome some judge finds your accommodation? We used to have courts of justice. Then we had courts of law. But now we are saddled with courts of opinions. How can we build a just and stable justice system on such shifting sands? I am happy for Mr. Groff. I think he got the correct decision that his right to take Sundays off to observe his Sabbath was infringed by the U.S. Postal Service illegally. But the fact that it's built on this towering sand pile of myth and legend and judicial telephone scares me. Because all it takes is one judge to say, "No, I think that's a little too much. Your right to express your religion how you see fit cost that one employer just a little bit too much." It doesn't even have to be a government employer. It could be a private employer. There's such a mess here that I don't think we should lose that simply because Mr. Groff ended up in the end with a decision that is just for him. What about the rest of us? I've been working on a 3-part series on the 3 branches of government, and the judiciary is up next. This maybe gave you some good fodder for that particular episode. If you want to find out more, you want to find out other videos and articles, well, please head to the website, constitutionstudy.com. And please sign up for one of the mailing lists. You can sign up for my monthly newsletter, my weekly insider update. You can even sign up to have my posts, my articles, my videos emailed directly to you when they post. It's all there on the website, constitutionstudy.com. Maybe head over, buy a book, ask a question. I love when people ask questions, or just donate to the cause. Maybe you'll even check out the Patriots program. There's a lot going on over there, and I've got updates coming that will make it even better. At least I hope you think they're better. Whatever you do, please consider to look at the details of these cases and how they do and do not protect your rights. If you find this interesting, share it with a friend. Be glad for Mr. Groff, but be worried and concerned for the rest of this country. And maybe next time you'll join us with a couple of friends at the Constitution Study.